In Connecticut, a hunter can legally own a firearm silencer and still commit a crime the second he points it at a deer. Same man, same silencer, legal to own, illegal to hunt with. He can pass the federal background check, get fingerprinted, wait for Washington to mail him a stamp, hang the thing on his rifle in his own living room. And the moment he carries it into the woods for the one thing most people buy it for, he's breaking the law. And here's the part nobody tells you at the gun counter, which is where I've spent enough years to know how this sale goes. The reason that Hunter is in that trap has almost nothing to do with Connecticut. It has to do with a bill that just made national news for supposedly setting silencer buyers free. Because at the start of this year, the federal government did something gun owners had wanted for 90 years. They took the tax on a silencer down to zero. $200 gone. And the way it was sold to you, the headlines, the celebration videos, the stamp is dead posts, you'd think the cage got unlocked. It didn't. They took the price tag off the cage. The cage is still there. And I'm going to show you exactly what's still locked, because if you walk into a store this year thinking a free stamp means you're free, you are going to get a very expensive lesson about the difference between a tax and a leash. Let me tell you what actually changed, because I don't want to be the guy who cries scandal when something good happened. Something good did happen. On July 4th of last year, a federal law most people call the One Big Beautiful Bill got signed, and buried inside, it was a section that dropped the federal transfer tax on silencers from $200 to zero, starting January 1st of this year. Not a discount, not $200 down to $5, zero. If you buy a suppressor today, you do not pay that stamp fee. That's real, that's a win for the buyer, and I'm not going to pretend otherwise. For a $500 can, that $200 was a markup of 40% that just evaporated. Wait times fell too. We'll get to how far. So the tax is dead. Good. Now watch what they left standing. Because that same year, there was a much bigger push, a real one, to take silencers out of the National Firearms Act entirely. To make them like any other rifle accessory. You'd buy one off the shelf, walk out, done. That was the Hearing Protection Act. That was the goal. And in late June of last year, the Senate's own rule keeper, the parliamentarian, the person who decides what's allowed to ride along in a budget bill, killed it, ruled it couldn't stay in. So the part that would have freed the product got stripped out, and the only piece that survived was the piece that took the money off the top. Think about what that means. The one change that would have removed the government from the transaction. Dead. The one change that costs the government revenue, but keeps its hand on your shoulder. That's the one that lived. They kept the paperwork and threw away the invoice. And a lot of people cheering couldn't tell the difference, because the invoice is the part you can see. Here's the part you can't see, and this is the whole video, so stay with me. Nothing else about buying a silencer changed. Nothing. You still fill out an ATF Form 4. You still send in your fingerprints, actual ink and card fingerprints, or the electronic version. You still send a passport photo. You still pass an FBI background check. You still notify your local chief law enforcement officer that you're buying one. And you still wait for the federal government to approve you before you're allowed to touch it. When they say yes, your name and that serial number go into a federal registry that has your silencer on file forever. That's not me editorializing. The companies selling these cans will tell you the same thing in their own celebration posts. The Form 4 stays, the background check stays, none of that goes away. They're words, more or less. They're happy about the price. They're quiet about the leash. So let's be precise about what you're actually buying. You are not buying a muffler you can pick off a shelf. You are buying a background check, a fingerprint file, a photo on record, a notification to your local police, a spot in a federal database, and a waiting period. And now, as a bonus, a $0 receipt. The government didn't let go of you. It stopped charging you for the privilege of being held. I watched this sale 100 times from behind the counter, and the paperwork never once got shorter. The customer's face when you explain that a free stamp doesn't mean free, that there's still the fingerprint card, still the photo, still the sheriff notification, still the wait. That face didn't change this year either. What changed is the line at the register got longer, because for a lot of people that $200 was the whole thing keeping them out. Drop the price, and the crowd shows up. But every one of them walks the exact same paperwork I walked buyers through 5 years ago. The doorway got wider. The room behind it is identical. And I want to be fair here, because this channel is worth nothing to you if I only show one side. there's a real argument for why some of this exists. The National Firearms Act goes back to 1934, to the gangster era, when the idea was to put a heavy hand on the kind of gear people associated with organized crime. That's the origin. And the Justice Department, defending all of this in court right now, argues that silencers aren't the kind of thing law-abiding people typically own for lawful reasons, so regulating them hard is fair game. That's their position. I'm putting it in front of you so you can judge it, not so I can knock it down cheap. But then you look at who's actually buying these things, and the argument starts to wobble. According to the industry's own owner study from last year, when you ask silencer owners why they bought one, hunting is the second most common answer, about 30%. Right behind target and recreational shooting. Home defense is way down the list, and this isn't some shrinking little hobby. That same study put the growth in federal silencer approvals at roughly 265% over 4 years, with better than a third of buyers being first-timers, and the whole market valued north of $800 million. This is not a niche toy for a strange little corner of the market. The registry crossed 6 million silencers this year, 6 million. The number of hunting-specific Form 4s in a single recent month ran nearly 400% over the prior year's monthly average. And in the first 3 months of this year alone, suppressor transfer forms hit around 73% of everything that got filed in all of last year. Read that back. 1 quarter nearly matched a full year. The thing the Justice Department describes as not typically owned is sitting in the safes of ordinary deer hunters by the millions, and more of them line up every single day. Which brings me back to that hunter in Connecticut, because now you can see why he's stuck. He did every single thing the federal government asked. He's in the database. He waited, and it bought him nothing, because the leash isn't only federal. It runs through all 50 states, and every state gets to tie its own knot. Here's the map, and this is where you need to be paying attention if you're about to spend money. 42 states let a regular citizen own a silencer. Of those, 41 let you hunt with it. Do the subtraction. 1 state, exactly 1, lets you own the thing and forbids you from using it on game. That's Connecticut. The statute is right there in the state's hunting code, and it says plainly that no person shall use a silencer on any firearm while hunting. Own it, sure. Hunt with it, and you've crossed a line the state drew on purpose. And they've kept drawing it. Last year, a state representative up there introduced a bill to finally let hunters use suppressors in the field. It went into committee and it died there. Didn't pass. So, as I'm making this, Connecticut is still the one place in America where you can legally register a silencer with the federal government and legally get arrested for hunting with it. You paid back when there was a fee. You registered, you waited, and the deer is still off limits. Now, I want to flag one thing honestly, because I found conflicting information while digging on this. There's a second state where the sources argue with each other about whether hunting with a suppressor is allowed, and I'm not going to name it as a sure thing, because I couldn't nail it down to a clean answer, and I'm not going to hand you a fact I can't stand behind. Connecticut is the one I can prove. Connecticut is the one you should remember. But Connecticut is just the loudest version of a quieter problem, which is that legal to own and legal to hunt with are two completely different questions, and the gap between them lives in the fine print of your state's game regulations, not in your federal paperwork. Your ATF stamp says the federal government is fine with you owning it. It says nothing about whether your state's Fish and Wildlife Agency will let you carry it after a specific animal in a specific season on a specific piece of public land. Those are separate rule books. The stamp doesn't touch them. Let me give you a couple of real examples of how that fine print bites, because I had to correct my own assumptions on this while I researched it, and I'd rather you learn it from me than from a warden. I'd assumed a few states made you get an extra state-level permit with local police sign-off on top of the federal process. Turns out that's outdated in the place I thought it applied. That state now just points back at the federal rule, no extra local permit, so credit where it's due, that particular hoop is gone. But the same state has a different trap hiding in its code. Get convicted of certain hunting violations with a suppressor on your rifle, and you can lose your hunting license for 5 years. Not a fine. 5 years of no hunting. The suppressor turns an ordinary violation into something that costs you half a decade in the field. And in the states that do allow it, allowed still comes with an asterisk, because your state game agency, not the ATF, not Congress, sets the season by season. Species by species rules, and those can move on their own, independent of the gun laws entirely. One state might let you run a suppressor on a coyote all year and say nothing about deer. Another might allow it on general public land, but not on a wildlife management area that posts its own regulations at the gate. None of these is outrageous by itself. The point is that your federal stamp is silent on every one of them. It answered one question: can you own this? And left the question that actually gets you arrested completely untouched. The lesson isn't a list of states to memorize, because those change, and I'd be lying to you if I pretended a video could freeze them in place. The lesson is the habit. Before you ever hunt with the thing, you check 2 rule books, not 1. The federal stamp is the easy one. The state game code is the one that puts you in front of a judge, which is the exact moment to say the thing I'm legally required to say and happy to say: this is not legal advice, and I'm not your lawyer. I sold gear. I read the forms. I am telling you the trap exists, so you go verify your own state before you load up, not so you take a YouTube narrator's word as gospel and blame me from a courtroom. Check your state. Every time. It changes. And if you think crossing a state line fixes it, I've got worse news, and this is the part where I have to correct something you'll hear repeated all over the internet, including in places that should know better. You will hear people say that to travel across state lines with a registered silencer, you have to file a form with the ATF first, a 532020, the Interstate Transport Form. That's the standard advice. It's also wrong for silencers. That form and the law behind it cover machine guns, short-barreled rifles, short-barreled shotguns, destructive devices, the heavy stuff. Silencers are specifically not on that list. So the good news is you can drive your silencer across the country into any of the 42 states where it's legal without asking the ATF permission. No form, free to travel. Here's the trap that replaces it, and it's worse, because it doesn't come with a form to warn you. The danger isn't a federal paperwork slip. The danger is driving into one of the states that bans the thing outright. Because there are 8 states, plus Washington, D.C., where owning a silencer is flatly illegal no matter what federal stamp you're holding. California, New York, New Jersey, Illinois, Massachusetts, Hawaii, Rhode Island, Delaware. Your federal approval means nothing the second your tires cross into one of them. In New Jersey, it's a felony-grade offense with mandatory minimum baggage attached. In New York, it's a felony that can run you years in prison. That perfectly legal, federally registered, can in your trunk becomes a prison sentence based on nothing but which state's asphalt you're parked on. Not because you did anything with it, not because you fired it or hit it or lied about it, because you drove. The object never changed. The map under it did. But there's a federal law that protects travelers, you're thinking. There is. It's called the Firearm Owners Protection Act. And on paper it says, if you're just passing through, locked up, unloaded, not accessible, a hostile state can't nail you for gear that's legal where you started and where you're going. On paper. In practice, the Northeast has a long, ugly record of arresting law-abiding travelers anyway, and letting the courts sort it out years later. Now, I have to be careful and precise here, because the cleanest documented case of this is a handgun case, not a silencer case, and I'm not going to blur that line. A man from Utah, not a criminal, a licensed, careful gun owner, had a flight delayed at Newark, got forced to stay overnight, and got arrested for a firearm that was legal at home and legal at his destination. He spent days in jail. The charges were eventually dropped, and when he sued, a federal appeals court ruled against him, decided that the second he took his bag to the hotel, the gun counted as accessible, and the protection he was counting on evaporated. That's a real ruling. That's a handgun, to be clear, not a suppressor. I couldn't find a clean, named court case of someone jailed specifically for a silencer in transit, and I'm not going to invent one. But the principle is the same, and it's chilling. The federal shield you think you have is thinner than the marketing suggests, and a silencer, banned outright in those states, not just restricted, is a far heavier thing to be caught holding than the handgun that already put a man behind bars. So put the whole picture together, because this is the reveal, and it's simpler and uglier than any single law. The story you were sold this year is that the government freed silencer owners. What actually happened is the government removed the one part of the system that cost you money and kept every part that costs you your freedom. The $200 was never the cage. The registry is the cage, the fingerprints, the photo, the background check, the federal file with your name on it. That's the cage. And that cage is exactly what makes everything downstream possible. Once your name is in the book, the government knows the can exists, knows it's yours, and every state and every game warden downstream inherits that knowledge. The file is the hinge the whole trap swings on. It's why a hunter in Connecticut can do everything right and still be a criminal in the woods. It's why a guy driving through New Jersey with a federally approved can is one traffic stop from a felony. The leash didn't get cut this year. It got cheaper, that's all. And cheaper is not free, no matter how loud the celebration was. If a channel that reads the paperwork so you don't get blindsided at the counter is worth something to you, subscribe. Because this is the stuff nobody selling you the product is going to say out loud. Here's the honest other side, and I'll give it to you straight, because honesty is the only thing this channel has to sell. The tax coming off is a real win. You save money now. The wait to get approved has collapsed compared to the old days. The median approval time on the electronic form this January was running around 11 days, when people used to wait the better part of a year on paper. That is genuinely one of the biggest quality of life changes this product has ever seen, and I won't wave it away to score a point. When the tax went to 0 on January 1st, the ATF got slammed, something like 150,000 electronic filings in a single day against a normal day of a couple thousand. They processed 250,000 forms in that first month, and by spring, the electronic system was carrying the overwhelming majority of everything that came in. And that stampede happened even though the agency had just come off a government shutdown the previous fall that froze its firearms branch for weeks. And even though the electronic portal itself went dark for the last stretch of the year while they rebuilt it for the new zero tax rules. People waded through all of that and still filed in numbers nobody had ever seen. So the system is faster and cheaper than it has ever been. I'm not going to stand here and tell you nothing improved. It did. But faster and cheaper access to a cage is still a cage. You are still asking the federal government for permission. Your name is still going in a book. And the states are still free to take that federally blessed object and make it a crime in their own borders. For hunting, for driving, for existing on the wrong side of a line. And there's one more thing hanging over all of this that decides whether any of it lasts. So I'm putting a date on it. Right now, there's a lawsuit working through a federal court in Texas, and the lineup behind it tells you it's serious. Gun rights groups, silencer makers, and big-name retailers all pushing together, joined by 15 state governments. Their argument is clever. The whole legal basis for the silencer registry, going back to a Supreme Court decision in the 1930s, was that it was a tax, and Congress is allowed to tax. That was the hook the entire scheme hung on for 90 years. But now, the tax is 0. So the plaintiffs argue the constitutional floor just fell out from under the registry. No tax, no taxing power, no registry. The Justice Department fired back late last year with a completely different theory, that Congress can regulate this under its power over interstate commerce, tax or no tax, and it leaned on a recent federal appeals ruling that treated silencer regulation as presumptively lawful. As I'm recording, that case had a long hearing in early July, and the judge took it under advisement. No ruling yet, no injunction. The registry is fully enforced today, and nobody can hand you the exact date that changes, if it changes at all. So here's where that leaves you, and it's the reason to understand this now instead of later. If that court strikes the registry down, the loudest villain in this video, the federal file with your name in it, could weaken or disappear. But watch what doesn't move, even if that happens. Connecticut's hunting ban is state law. New Jersey's and New York's possession bans are state law. A federal court knocking out the federal registry doesn't touch a single one of them. The hunter in Connecticut is still stuck. The traveler in New Jersey is still one county line from a felony. The federal leash might get cut. The 50 state leashes stay tied. For context, and just so you feel the full weight of how strange the American setup is, in a lot of the world, the silencer is the boring part. In Norway, you can reportedly buy one over the counter. No license, no permit, no registry, the way you'd grab a scope off the wall. In Finland, if you already hold a valid firearm license, the suppressor is a free purchase, with no separate approval stacked on top. Sweden reclassified them a few years back, so they're now about as hard to get as a box of ammunition. New Zealand sells them cheap and thinks nothing of it. Plenty of rifles there come threaded for one straight off the shop rack. Most of those countries regulate the gun far harder than we do and treat the muffler on the end of it like the accessory it is. We flipped it. You can buy the rifle in an afternoon and spend weeks getting federal permission for the thing that makes it quieter and easier on your ears. That's the absurdity in one sentence. America treats a noise reducer like a weapon of war and a rifle like a Tuesday. So back to that man in Connecticut, standing in his own living room, legal silencer on a legal rifle, federal stamp in a drawer. He did everything they asked. He paid when there was a bill to pay. He got printed, photographed, checked, filed, and approved. And he still can't walk into the woods and use it because owning it and using it were never the same permission. And the year everyone told him he got free, all they really did was stop charging him for the lock. Legal to own, illegal to hunt with, same man, same silencer. That was never a tax. That was always a leash. And the leash is still on. If you want the video where we tore apart the thing they don't want you to see on the certification sticker, it's right there, and it runs on the same idea as this one. The paperwork is the product, and the product is a story. I'll see you in that one.